We're going to talk about estate planning today. I'm investigator Christelle Bell with the Let ABC 15 Know team. Thank you so much for joining us. I'm really excited about this topic because it's so important, and I'm really, really excited to have our guest with us, Mr. Mark Paquette of Law Offices of Mark C. Paquette, joining us today to talk about estate planning. Mark, thank you so much for joining us today. Really, really excited about this topic because it is probably one of the most most known topics that we offer for Let ABC 15 Know. When we host a phone bank, the calls come in, they are nonstop. You volunteered to answer our phones for a phone bank before, and we'll talk about that phone bank that's coming up July 15th too. But also, just whenever we host our Big on the Road event, we have a lot of people who come in because they want to make sure they have their affairs in order.
Yes.
And I always say it's one thing, two things for sure, right? One, we're born, and the second one is we must die, right? So, it's very important that we have our affairs in order. So I'm glad that we're having this conversation to hopefully educate folks out there about what they need to know, what they might not know, and what's important when it comes to estate planning. You ready?
Yeah, I'm very ready. Let's go.
I guess so. My first question is, people always want to know, do I need a will or do I need a trust? And then what's the difference between the two?
Okay. Yes, you do.
Mhm.
And you need it from age 18. I joke around with clients and tell them it's called estate planning for a reason.
Mhm.
One of the gifts that some parents could give their 18-year-old children is a simple will package. Now, you asked what's the difference between a will and a trust. When you have a will, you're basically telling the world, if anything happens to me, this is what I want done with my stuff. A trust allows you to have a little better control. Anything that's in a trust can avoid probate, whereas the will does not. If you have just a simple will package, if your estate needs to be handled or determined, approved, that's what probate stands for, approved by the courts, you need to file a probate action. I try to inform clients that you don't want to avoid probate completely. What you want to do is minimize it, and that's why you need a trust.
Now, you mentioned 18 as an age because that was a question that I had, like, when is a good time should we, start planning our affairs? But you're saying at the age of 18. Why? Most people think, "Oh, my 18-year-old doesn't have anything." Like, what why 18?
Well, it's funny you say we don't have anything. I
Well,
sat with
most of them
no,
don't.
no, I
Nowadays
understand,
they do,
but
right?
the realization is at that age we are wealthier dead than we are alive
Oh,
because you don't
yeah.
think of what you have. But age 18, you're an adult now.
Mhm.
So if you happen to pass before that, or if you happen to get sick prior to that, then your parents can make decisions and take care of things.
Mhm.
As you turn 18, because it's the legal age of majority in this country,
Mhm.
now you need documents to state who is going to do it. One of the advantages of attending college or something like that, your parents still have certain rights with respect to medical decisions and stuff like that, but they lose rights on making financial decisions for you.
Mm.
So if you, let's say you take out a couple credit cards in college, where a lot of kids they hit up on stuff like
Yeah.
that. If something happened to them and they became incapacitated, the the parents can't work with the credit card companies, or they shouldn't be able to work with the credit card companies to resolve any issues
Mm.
until someone's appointed as a general durable power of attorney.
Mhm. Yeah. And so I guess when you talk about having your affairs in order too, life insurance also, that can also be in the will or the trust or whatever.
Well, life insurance actually works outside of probate. That's technically considered contract law, but it should be incorporated in some fashion.
Mhm.
When you have a good will package, you'll have what's called the last will and testament.
Mhm.
That will cover for things when you pass. You should have a living will. So when you are not able to make decisions for yourself, but you're determined to have reached what's called an end medical stage. such as a persistent vegetative state, irreversible coma, or terminal illness with an incapacity. You get to make the decisions while you are able to on how much heroic care you get. Then you should also have the general durable power of attorney, which covers finances, and a durable power of attorney for health care. So that way you get to make the decisions when you're able to, but if you become incapacitated, the person that you trust the most and knows your wishes will make those decisions and make sure they're adhered to. With
Yeah.
regard to the insurance, because that is contract law, it technically passes outside of probate law by what we call is operation of law.
Mhm.
So if someone passes and they have life insurance, you just need to show the life insurance agency you're normally a certified death certificate,
Mhm.
and they'll pay out to whoever is listed as the beneficiaries.
Sharon. Gotcha. Okay. And I guess that's the next question is what documents do I need to prepare a will, a trust? What documents typically what they would need to use for preparing?
Well, when we put together a will, they can be very simple sometimes. Just state your name, that you're 18 years of age and older, and you're able to make the will,
Hmm.
who you want your assets to go to, if there's anything special or specific gifts, who they want to go to. You need the durable power of attorney, medical power of attorney, the living will, and it comes down to what your wishes are. If let's say you came to see me in my office and you wanted to put this together, I would have you bring the names and contact information of anybody you want to be your agent, whether it's the power of attorneys or a successor trustee if we did that, or it's the executor, or we call them personal representatives here in Arizona for the last will and testament.
Hmm.
So if you have that information, then we would sit and discuss what your wishes and desires are as you plan your life for the next 5, 7, 10, 15, or even longer years to determine what's the best way to plan out your estate for yourself and for who you wish to leave things to, and how you want to take care of yourself in case something happens.
Okay. So, most of the time people say, well, I really don't have a lot of things. I really just have my home. What options do they have?
Well, with respect, everybody actually has a lot more than they
I,
believe.
I believe
You know,
that too, right?
you have a home. Let's say somebody has a nice modest home, 1,500 to 2,000 square feet. It's fully furnished. They have some jewelry, maybe a little bit of artwork or family heirlooms and stuff like that. That all has value into it. So even the 18-year-old kid, he gets maybe a car, he has a nice watch or some jewelry, or he's got family gifts that he's saved, or maybe didn't. Maybe he spent it on something else, but all
Hmm.
those things he spent it on
Hmm.
has a value, and that's considered part of your estate. So what you have to do, depending upon the size of your estate, depends
Hmm.
upon what you should be setting up. Either the simple will package, and as you mentioned earlier, 18-year-olds don't think they have anything.
Hmm.
Well, we know that they do, but they may not have enough that would warrant setting up a trust at that time.
Hmm.
As you get older, you start acquiring more things, you get married, you start having kids, then you're going to create a trust and it will incorporate your will and other documents as well.
Hmm.
With respect to talking to an attorney about stuff like that, you base it on what your net worth is at the time and what your expected growth is based on what you're doing. And we're fortunate now that we have a $15 million estate tax level. And if you're married, you can double that to 30 million with what's called an AB trust. So less than 1% of the people in Arizona would be concerned about a tax reason.
Hmm.
But to set up the trust, you have to think about privacy for your survivors, and you have to think about whether or not you're leaving anything to anybody under the age of 18.
Hmm. Gotcha. Okay, so many people ask, what will happen to my bank account when I'm gone? Is
Okay.
that part of your will or your trust?
Well, actually, all of that is part of it, becomes part of it. It
Hmm.
becomes part of your estate. So if you have checking account, savings account, you have a car in your name, you have credit cards in your name or in your joint name, and those are treated differently based on what they are. They will be treated, the person who you select to be your personal representative will file a probate with the court. He'll get appointed as the personal representative, and he's given what's called letters of testamentary or letters of personal representation. He then uses those letters to talk to the banks, talks to any investors you may have, and then those items will be incorporated into your estate. All your just debts will be paid off. And then if there's anything left, it'll be divided up amongst your heirs or beneficiaries as you wished.
Now, here's the thing people really need to understand because when you talk about this sounds like, oh, this will happen in 48 hours. That's not always the case.
No, it's
Right? So, yeah, you say it, but it's a process.
it,
Yeah.
it is a process. And I think one of the things the legislature in Arizona did right was it takes approximately 10 days to get a death certificate. I have received calls from clients literally hours after their loved one passed, whether it be a parent or somebody. And I try to explain to them, I says, there's nothing we can do until you get a death certificate. Please take this time to grieve, think about what you want to do, think about how you'd like to honor that person and things like that. And don't worry about this portion because you technically have up to 2 years to file something with the probate courts if necessary. And get it resolved that way. But generally speaking, you don't get the death certificate for at least 10 days. And depending upon which funeral home you go to, it could be as much as 2 weeks to 3 weeks. But that still leaves plenty of time to take care of anything and file the probate if necessary or transfer other assets as
Yeah,
needed.
absolutely. Okay, so when you talk about the most important things people need to understand about estate planning, what are three things people really, really need to take away from this conversation when it comes to estate planning?
Okay. When it comes to estate planning, if it's not in writing, it could cause a problem later on. As an example, I've had a client who had 6 kids. One of them, unfortunately, was in and out of prison their entire life. The parents didn't want that child to get any money up front. So if they didn't set up a trust and didn't have a trustee that they could count on to make sure the money was doled out, that child would get their share of the inheritance right away. If they had no will set up, then they would get their share per line of succession. So the important thing is if you have something that you want to ensure is given to exact person, or you want amounts different for each child based on what's going on in their lives, you need to make that in writing. So whatever your wishes are, make sure it is fully detailed when you talk to your attorney of that nature. The other important thing is to update it on what is considered 5 life-changing events. So if, let's say we sat down and we put together a trust for you, signed off on in a couple weeks,
Okay.
and if any of these events happen, marriage or divorce, death of someone in the document, such as a trustee or an agent or something of that nature, or someone who is receiving something,
Okay.
buying or selling of a business, buying or selling of a home. And here's one that most people don't really get, but when you get a large infusion of cash into your estate, whether it's by inheritance from someone else or you be one of those players that happen to win the lottery, you got
Yeah.
lucky.
Or you hit the casino.
Yeah, or you go to the casino or something like that, and you win a substantial amount of money. Those are things you should contact your attorney and say, listen, this is what's happened. What do we need to do with my trust documents? Just to make sure everything stays, up to date. I usually meet with my clients between 5 and 7 years. I will, if unless they call me first saying one of those events happened, I will send out a nice email to them saying, hey, it's been 5, 6, 7 years since we've talked. Has any of these events happened? Do we need to update anything? Any changes in these circumstances?
Yeah.
And you find out if there's no, then it's all right. I'll talk to you again in 5 or 7 years. And
Yeah.
if there's yes, then they call me back and say, hey, this is what happened. And because a lot of attorneys we're required to get continuing legal education credits.
Mm-hmm.
We stay up to date on the laws as they currently are
Yeah.
and prospective changes to it.
Okay.
So
That's good.
if something happens that's going to change how the trusts are designed, then, we'll either incorporate that first or before it changes so that we don't have to make changes going forward.
Okay. The third thing.
The third thing
Yeah. One more
that
thing.
is very important,
Yeah.
keep them in a safe place.
Ah.
I have a few clients, they change houses of like every 3-4 years,
Okay.
and they always seem to lose their estate planning documents. So they call me up and I have to do restatements and things like that.
That's costly.
It
You
is
gotta do,
costly.
yeah, because
Yeah.
you gotta,
So I got to retype things up. I need
yeah.
to do a restatement saying that the original document was this, and now we do a restatement because it was lost or whatever. Now, personally, I don't mind because I'm a lawyer. I enjoy making money like everybody else.
That's what I was like. That's costly.
But
But for you,
yeah, so for them, if they keep the documents in a secure place,
Yeah.
I always recommend, you know, if your bank offers a safety deposit box, keep a copy in there, keep the original in there.
yeah.
I also offer to my clients that they can send me, after we sign off on them, a digital copy of everything that I can certify as a correct and true copy if needed later on.
Okay.
Some take advantage of it, some don't.
Yeah.
And
But I guess for that too, your loved ones need to also know where those documents are.
yes, that's very important too, is who you select to be your agents, whether it's the power
Yeah.
of attorneys or the successor trustees or personal representative. I also recommend that you send a copy to them.
Oh, yeah.
And I sometimes tell them, keep it sealed, and tell them only open it in case of an emergency.
Mm-hmm.
But even better than that, as I always say, sit down and talk to them.
Mm-hmm.
Sit down and let them know what your wishes are so there's no surprises later on.
Yeah.
If you're going to select, so let's say I have one situation where there were 3 kids. The oldest son was a lawyer in Virginia,
Mm-hmm.
doing very well for himself. They wanted to limit what they gave him and focus a little more extra to the other 2. They sat down with all 3 kids, explained what they were trying to do, and that attorney said, Ma, Dad, give everything to them. We don't need the money. And this is, even our kids are going to be taken care of. Everything's all set. It's a nice gesture, but they could use it for their kids, for education and everything else. And so when you open up and talk to your kids about it, you'll find that that may alter your estate planning a little bit as well.
And sometimes it may be difficult to have that conversation. Do attorneys kind of help with having that conversation too, having that, like that mediator too? Because it can be uncomfortable. You don't want to talk. I don't want to talk to my mom right now about when she dies, but I know it has to happen. But sometimes having someone who's outside the family can help with the conversation too.
It is. And, I try to impress upon clients and individuals that if you're the one who's setting up the estate plan, you're the one who should set up the conversation.
Yeah.
You just mentioned that you don't want to talk to your mom or dad about possibly having put together their estate plan.
Yeah.
But there are ways to help with that as well.
Yeah.
You can say, I'm learning this stuff. Have you heard about any of this, or have you learned about any of
Yeah.
this?
Yeah.
Have you done any of it?
Yeah, yeah, yeah. And for sure. And we have that conversation. But sometimes it is,
It's very difficult.
it's difficult, but I know that it's necessary, right? So, but sometimes I've heard families can have someone come in to kind
Yeah.
of help make that a little bit more of a comfortable conversation. So it's not so much pressure. So I want to kind of go through a couple of other things because a lot of people do not think about this. And it's just going back to you talking about, we don't think that we have a lot of things. We think, oh, I just have a home. But what about your digital assets? What about your your virtual intellectual property? What should we think about with that? And what is that?
Well, they have several different types of digital assets.
Yes.
One of the things I do now is I have a booklet that I I found on Amazon. And as a result, it has a section for digital assets. And most people don't know your email is a digital asset, your Facebook page, your LinkedIn page. I and I gotta apologize. I'm not good on social media. I think there's like an
Yeah,
Instagram,
Instagram, yes.
yeah, things like
If you're
that.
on TikTok, yes,
So
yeah.
one of the things I find shocking once in a while is I get a notice or something from someone who I know has passed away 4 or 5 years. So I will, if it's from LinkedIn where I am on, I will let them know. I says, you should check your records. This person passed away in this time. But the book allows you to list all that stuff. It lists all the digital accounts you have. You can put your email addresses in there. You can put your logins for those so you can go and close them out for the dearly departed, so to speak.
Yeah.
With respect to like cryptocurrency,
Mm.
NFTs or non fungible tokens and things like that, you have account numbers for those. You need to make sure that those are known because there's a lot of individuals who keep that private. And if their family may be entitled to millions of dollars in cryptocurrency,
Whoa,
they
yeah.
lost out because you don't let them know how to find it and get to it.
Yeah. Yeah.
So those are things that you should, make sure you keep accurate information. One of the other things you can do is, from a digital standpoint, I do a lot of backup on a exterior hard drive
Hmm.
on stuff, so that way I don't have to worry about cyber crimes and stuff.
Hmm.
Do something like that, and then just let them know how to access that particular drive.
Hmm. Okay. Um, again, going back to talking about we don't think that we have a lot, but as life goes on, we begin to accumulate things. We have belongings. Should we be making an inventory of the things that we have as we get ready to prepare our estate plan?
That's a difficult question because it's something, it's specific to each individual.
Yeah.
With respect to doing an inventory, I think it's important to do an inventory no matter what. Whether it's simply you taking your cell phone and taking a picture of everything in your house and storing that somewhere, for insurance purposes. Your house burns down or something like that, you've got that for insurance purposes. With respect to doing it for your estate planning purposes, some things you're going to get rid of on a regular basis.
Hmm.
Computers don't last. Cars, people sometimes change them in once a year or once every 4 years.
Hmm.
Certain things you're not going to list in there because you may not have the same vehicle that you had when you first started. If the natural course of life, you set one up now and you live another 30 years, you may have gone through 4 cars. But with respect to certain items that are important, I usually recommend anything that's non-electronic over $2,500, anything that's a family heirloom that you want to make sure it gets passed down or stays in the family. Anything that has, certain sentimental value, it may not be a family heirloom, but
Yeah.
something that you had, is list those things. I had a client that used to love traveling. He was with Lions Clubs International, and he would buy artwork from around the world.
Yeah.
And you walked into his house, and it honestly looked like a museum with all the pictures hung and everything else. And he says, "What am I going to do with all these?" So I says, "Well, there's two ways to do it. You can start writing everything out, or two, invite all your kids over, tell them, give them each a different colored sticker and say, put the sticker on the back of the painting you want. And when I go, we'll make sure you get that painting.
Oh,
Anything
yeah.
that's not, it doesn't have a sticker on will be sold or turned over to a museum or whatever. And that
Yeah.
way they can, they'll know what they're getting and what's not. So you can keep track of things that way.
That's a good idea. Yeah, for sure. Mark, this has been so enlightening. I thank you so much again for taking out the time to have this conversation because, again, it is very important. And because it is important, we are hosting our phone bank coming up July 15th from 5 to 7 p.m. You can speak with an attorney over the phone to get help with your estate plan. That's going to be, again, July 15th. That is a Wednesday from 5 to 7 p.m. We'll give you the number to call. Mark, along with other volunteers, are going to be answering your phone calls to help you with your specific questions. You can have your questions ready, have your documents ready. We want to get to as many people as we can with those phone lines. So make sure you're ready, you're prepared. We'll give you the number to call. But again, mark your calendar because it's coming up July 15th from 5 to 7 p.m. You can call our phone lines to get estate planning help for free. So we're excited again. Mark and other volunteer attorneys are going to join us. We're partnering with the State Bar of Arizona to host this for you. Again, it is free. So we're super excited about it. Mark, again, thank you so much for having this conversation. We appreciate it.
Thank you. And I truly appreciate it and you guys doing this because 70% of the population out there have nothing in place and they're relying on the government to help them. This at least gets people the information they need.
Yeah, for sure. All righty. Well, thank you. We'll see you next time. Thank you for tuning in.